Okay, we're ready for round two. Except for my, yeah, we're rolling on. Whether we're ready or not, we're gonna do round two. Okay, thank you, everybody. We're gonna continue on. Let me note a couple of things. First, the documents that were referenced by the three speakers, the three presenters this morning, are available in hard copy here. They will be available as soon as possible on the Office of Planning and Research website, opr.ca.gov. And the Strumwasser report will be available on the PUC website as well. So, and Stephanie, why don't you raise your hand if you want to do a comment. How are we doing it? Are we doing a sign up or? Okay, so let Stephanie know if you want to make a public comment. So now we're gonna hear some state agency comments. There are a wide variety of boards, commissions, and councils that Bagley-Keene and to some extent ex parte contact rules apply to. But they arise in different contexts, and there are some differing sets of issues as well as some overlapping themes. And so the best thing to do is to hear from three of those commissions and councils, starting with Tim Sullivan at the PUC.
Good morning. I want to thank the Governor's Office of Planning and Research for giving me the opportunity to speak today. And I would like to extend thanks to Ed O'Neill, Michael Strumwasser, Beverly Palmer, and Carol Delia for their very meaty presentations. I'm Tim Sullivan. I'm actually the new Executive Director of the Public Utilities Commission. And oddly enough, my office is right next to Ed O'Neill's. So I've heard firsthand many of his comments regarding the lack of communications, particularly from the executive level. And one of the things I've been doing as executive director is I drop in to visit workers and find out what they're doing. Just about 2 or 3 weeks ago, I dropped in on a young woman who manages or participates in $1 billion energy efficiency program funded by the state. And of course, I saw her workstation, and as you might expect, there are spreadsheets of numbers all over the screens. And I just asked her how she was doing and what was happening. And one of the things that happens when you communicate, people actually ask you questions. And she asked me the question, what am I doing to restore trust in the Public Utilities Commission? And as I think about it and what we're here to do today, the central issue is how to strike a balance between openness and transparency on one hand and effective and efficient decision-making on the other in a way that restores public trust, that maintains it or improves it or restores it, as the case may be. Now, I have to make a disclaimer as executive director. I'm not here to endorse any particular policy, but I will be focusing on some of the operational problems that arise both from the Bagley-Keene Act and from the ex parte rules. Now, the way I see it from an operational viewpoint, one of a fundamental task of the California Public Utilities Commission is to improve infrastructure investments that balance the needs of the state's economy, the cost and prices of those investments, and do so in a way that promotes safety. Now, our approval grants legal authority to utilities to go ahead and make the investment. But I can tell you, without public trust, our work becomes very slow and it can become unreliable as you get more challenges in the courts to our decisions. Now, I will talk first about the Bagley-Keene rules, and second, I will talk about the ex parte rules. But to make it short, I agree with much of what was said this morning. The Bagley-Keene Act as rules make it very hard to deliberate, almost impossible. And the ex parte rules, in my view, have failed to engender compliance, and they have drowned people in complexity that undermines public trust. Now, my first major point is that the Bagley-Keene rules discourage deliberations in meetings and even outside meetings. Now, their purpose was to make sure that the actions of state agency be taken openly and that deliberations be conducted openly. Well, as many people have said this morning, the outcome is to discourage deliberation or discussion. In my organization, the commissioners, it's almost impossible for them to discuss things. You don't get open deliberation. Instead, you get no deliberation. Why does this occur? Well, one reason, the press of business. For each commission meeting, there are over 60 items on the agenda. And God forbid, if the discussion actually led to a change in positions, the decision would have to be withdrawn, recirculated, and wouldn't appear for another 2 to 4 weeks. Second of all, as speakers have pointed out, we regulate about $60 billion worth of the California economy. So it turns out that virtually anything that a commissioner says has the opportunity to move markets, to make fortunes go up and down. So with that in mind, you can expect that they're going to be very careful in whatever it is they say. So that in itself discourages deliberation or anything that would suggest that there's some uncertainty in their mind about some particular strategy. A third item, which hasn't been mentioned, but in the ritualistic format of the public commission meetings, it's very difficult for technical staff to intervene and to provide up-to-date information or to revise factual misunderstandings of a commission. That doesn't occur. You just get basically a ritual that takes place, and the ritual goes on, and no one interferes with the priest in the front of the room. Now, the second point I want to make is that outside of a meeting, there's no discussion either. That was the point that was made by Carol Delia so very well. I have a very strong example of this. Rachel Peterson is the chief of staff to Commissioner Leanne Randolph. And I asked her, how does the Bagley-Keene Act affect your work? And the first example that came to mind was the governor's new policies to try and reduce greenhouse gas. Well, this is something that is, a large part of that is assigned to this commission. The task is unprecedented and it's complex. Now, it turns out that these issues include things like long-term procurement of energy resources, what the level of renewable resources should be, how much energy efficiency we will have in California, what will be the role of electrical vehicles, what sort of storage technology should we invest in and deploy, how we can use demand research. Now, it turns out these issues are distributed among all 5 commissioners because there's a lot to do. But what this means under the Bagley-Keene, there can be no discussion or planning about how these issues are handled, how they're resolved, or what the timing is, or even how much greenhouse gas they're reducing with either the commissioners or the advisors, because these are the very issues that will one day come before the commission. Now, I want to step aside a little bit and talk about contrafactual. As mentioned by previous speakers, there are some rules, some places where we actually can have deliberation in closed sessions. The 2 major ones have to do with when there's been a rate-setting meeting with hearings, or when there has been an adjudicatory case, a presiding officer's decision, and it's been appealed to the full commission. Now, I can explain, as executive director, I get to sit in on these closed meetings. And there, what you see is a process that's entirely different than the ritual that occurs in public. The commissioners sit around, they trade ideas back and forth, staff interrupts with new ideas, and you get a real sense of deliberation, a push for consensus, an exploration of the ambiguities. You get exactly what you would expect from a commission composed of 5 intelligent individuals with strong views and the ability to keep in mind many different concepts at once. For me, it's inspiring to see, but this is the very thing that the public cannot see because it's the type of deliberation that is unwise for it to occur in the public. And if we did this in the public, we'd probably decide nothing, because it would take too much time. At most, you can deliberate in public on maybe one or two of those 60 issues. Now, my next major point turns to the issues of ex parte rules. Well, they fail to prevent the back-channel communication, and I also want to point out that current ambiguity engenders suspicion of the staff for each other who engage in communications with outside entities, or between the staff and the commissioners. I want to point out that the Strumwasser and Palmer report was commissioned by the Commission. It was totally independent. It presents a harsh view of recent Commission activities, but it also suggests a very different future and ways to proceed. I think the report does a very good job of documenting why it reached those conclusions, and I'm very glad that the Commission has indeed chartered this report. Well, I guess its major conclusions is that the rules do not stop the back-channel communications. They're unenforceable as currently written, and they do nothing to develop trust. One of the points in the report stresses how parties don't trust commissioners, and particularly don't trust the ideas of conferences. Well, it turns out, in talking to the commissioners, I found out that there's another side to that matter. The commissioners themselves feel sometimes that they are subject to what they call drive-by ex partes. There will be at a conference, someone will approach them, will say something to them. They hardly know who the person is. They certainly don't know that they're representing an interest in the party. And 3 days later, they find on the Commission's website an ex parte notice describing the communication. Now, this can happen when some commissioners just don't want to have ex parte meetings on a particular issue. So they call it a drive-by ex parte. Of course, when they call up the person and say, well, why'd you do that? What you said, really isn't an ex parte communication. It was just a general policy discussion. And the answer that they get back is, oh, we did it on the advice of counsel out of, quote, an abundance of caution. Well, why is an abundance of caution needed? In my view, it's because it's unclear what the rules are. And so you, once again, have that problem. One last point I want to make. One of the things I find is that the very term ex parte, for anyone who's a lawyer, raises a red flag. Because in almost all contexts, ex partes are forbidden in the judicial context. And so once you say, oh, we have these rules for ex parte, it's almost as if you say, well, we have rules that cover some situations where stealing is okay, or something like that. You're just in a hole just from the very title that it's called. And as people has mentioned earlier, we call them all-party ex partes, which of course is a contradiction by its very nature. But you see our whole language and thinking has been almost corrupted by the complexities and nuances of this legislation, which doesn't make sense. Now, my third and last point is one that I think has been anticipated by Ed O'Neill. And that is that rules alone, changing these rules will not be enough. To achieve the Commission's potential, there needs to be systematic managerial change. That is something that I'm trying to do. One of the things I did when I first came on as executive director, I had a managerial team review the 65,000 emails that were released between PG&E and Commission employees. And what we found were there were many embarrassing and inappropriate communications, but I have to tell you, of all the ones that I reviewed, and I only reviewed those of people who are still working at the Commission, I don't think a single one was a prohibited communication. You had overfamiliarity, lunches, people saying, love you, or see you later, or all sorts of things like this. And I must say that maybe it's because of my age, but I have it hard to understand why emoticons would appear in communications between a regulator and the regulatee. It just doesn't make sense. It doesn't do what we want to do. Now,
Someone your age would know what an emoticon is.
I have a younger daughter. Okay, so what are we doing managerially? We're working hard to basically change the culture. We've had training for all employees on what communications by email should be like, what the proper stance is vis-a-vis the regulator and the regulatee, and also a blanket policy to push personal communications off the state email system. We're also trying to make managerial reforms that we hope will establish trust. And the way we do that is basically three things. We focus on performance, trying to change facts on the ground. The second is accountability, holding the workers responsible for what they do. And the third thing is transparency. We've made steps to put lots of statistics, lots of items on our processes now on the website for the first time, and we're actually redesigning our website. We've also adopted or we're in the process of adopting a code of conduct for all employees. We have a draft code for managers and employees. We're circulating it for comments, and I think we're probably adopt it as an aspirational goal for all employees within the next month. Now, just to sort of sum up, California has asked the Public Utilities Commission to perform big tasks in reducing greenhouse gases. The governor's goals are very ambitious. The workshop here, to me, engenders hope. The central issue today is how to strike a balance between openness and transparency, on the one hand, effective and efficient decision-making, on the other, in a way that inspires trust. We need the governor's assistance in creating a new balance in law. We need leadership from the governor and legislation to solve the types of problems we're facing. We have here in the room, there are a number of Public Utilities Commission leaders, and we need both the Commission's leaders and its workers to rebuild trust with the public and with each other. We are beginning to do it now. I want to thank you for this opportunity to speak and then mention go back to that story with the worker. To be quite frank, when she asked me the question, I didn't have an answer. But I knew that was the central question that we have to face. And a week later, I had her back and we had a full discussion about the steps we are taking and what she suggested. That is the type of thing that we need to do, and I'm glad it's happening today at this conference. Thank you.
Thank you very much. Insight into some of the complexities at your commission. All right, so let's move on to Courtney Vaccaro, Chief Counsel at the California Energy Commission.
I think my height is making this a challenge. Good morning. I'm Courtney Vaccaro, Chief Counsel with the California Energy Commission. And on my own behalf and behalf of the Commission, we thank you for inviting our perspective today on how state agencies can efficiently and effectively conduct business, while at the same time staying true to the Act's goals of open and transparent government decision-making. I think Ms. D'Elia, Mr. O'Neill, and Mr. Sullivan quite ably framed the key issues before us today on Bagley-Keene. So to avoid being repetitive and cumulative of the points that have already been made and well made, I'd like to focus, I think, on just a few areas of concern that the Energy Commission has. I think the primary area of concern is that under the 2009 amendments, it's difficult at best for our commissioners and for our staff to benefit from the multidisciplinary leadership structure that's established by law. So more specifically, under the Warren-Alquist Act, which contains the Energy Commission's enabling statutes, the governor is called to appoint 5 commissioners. One who has to have a background in engineering or physical science. One must be a lawyer admitted to practice law in the state of California and also have experience with administrative law. One must be an economist with experience in natural resource management. One must have background and experience in environmental protection or study of ecosystems, and one must be selected from the public at large. So each of these 5 full-time commissioners are tasked to lead specific projects or program areas within the commission. So on any given day, a lead commissioner is grappling with any number of complex issues. This could range or include program design, program implementation, or even making decisions that have far-reaching impact on energy markets. So not surprisingly, on any given day, a lead commissioner could benefit from the particularized and specialized expertise of 2 or more of the fellow commissioners. Under the 2009 amendments, the lead commissioner cannot sit and have a discussion, informal or otherwise, with 2 or more of the fellow commissioners or their agents or intermediaries, whether those are their specific advisors or commission staff, to benefit from supplementary and complementary perspective that could aid the lead commissioner in discharging his or her duties. I think this is something that we see as counterproductive and undermining of the very purpose of having a multidisciplinary leadership team. I think for us, this really hits home when the commission is working on the Integrated Energy Policy Report. Most people know this as the IPR. So we produce an IPR and IPR updates. This is a key statutorily mandated function of the Energy Commission. The IPR contains a number of far-reaching policy recommendations and addresses a number of matters related to energy markets. This policy document does not, however, benefit from the ability of the commissioners to collaboratively talk about the various sections or the various issues that need to go into the IPR. Instead, what we do is we take a lead commissioner format and designate that lead commissioner as the primary individual to identify the high priority topics for the IPR, both things that are current and pressing and matters that also are mandated by the legislature. That lead commissioner then prepares and scopes out public workshops and tees up the issues that will be presented in the IPR. So notwithstanding the pivotal role of this lead commissioner, each of our commissioners does participate in the IPR, but they only participate in 2 ways. One, in the publicly noticed workshops where a number of issues are vetted and their perspectives and points of view can be publicly shared, and in the drafting of individual IPR sections. Interestingly, when they draft these sections, they're not able to collaborate with one another. They can't have these informal discussions, again, directly or indirectly through advisors or even program staff for fear of violating the 2009 amendments. So instead, what happens is through advice of our office, as well as custom and practice over the past several years, the commissioners, their advisors, and staff engage in a fairly elaborate process where they are constantly trying to ensure that they know who may speak with whom at any given time on any given topic. It sounds easier said than done because, of course, it means that you've got to know who is speaking with whom. But again, the commissioners and their intermediaries can't have these direct communication. Others of us are minding the store and then ensuring that we're not acting as hubs ourselves to perpetuate or create prohibited serial meetings. It seems to us that the commission and the public would be better served if there were greater opportunities than are currently presented by Bagley-Keene for all of the commissioners to informally and collectively communicate on scoping and preparation of the IPR workshops, and then to also collaborate and benefit from collective wisdom and experience in the drafting of their IPR sections. I think a variation on that theme, but a slightly different topic, is that we feel that there should be better opportunities in Bagley-Keene for our power plant certification committees to have a greater ability to talk as well. So power plant siting is another key function or core function of the Energy Commission. And under the Warren-Alquist Act, the Energy Commission is required, it's not discretionary, required to establish a committee of at least 2 or more commissioners to preside over these quasi-adjudicatory proceedings that take anywhere, from a year or more to complete. Typically at the Energy Commission, we only assign 2 committee members to preside. One is deemed the presiding member, one is deemed the associate member. Ideally, the 2 would meet together collectively to address any range of matters, whether it's the scheduling of status conferences, disposition of discovery requests, disposition of motions, and anything else that might come up within the proceeding. And typically, they would do this in noticed and public meetings, and they do this assisted by a hearing advisor who functions much like an ALJ at the PUC, but without the title. And what typically happens is a number of issues come up in the course of a proceeding that require swift action. And that action cannot benefit from or is not amenable to the 10-day prior noticing requirement of Bagley-Keene. But absent the noticed meeting required by Bagley-Keene, one commissioner who sits 2 doors down from another commissioner on this committee, they can't talk. They can't talk directly, and they can't speak through their intermediaries to address these matters that require swift action. So what invariably happens is the presiding member, acting alone or in concert with the hearing advisor, decides matters on his or her own. The practical effect of this, I think, not to put too fine a point on it, is to marginalize the associate member, because you now have the presiding member acting on behalf of the committee without the benefit of the associate member being able to weigh in. This isn't something that happens every now and again. This is something that actually happens quite frequently in the context of power plant certification proceedings. So then the practical effect would be that we have a statutorily required 2-person committee that, for all intents and purposes, in a number of instances, functions as a 1-member committee. I think we're finding that to be problematic. And it seems to us that a better situation would be one which allows these commissioners to have informal and free-flowing discussions without having to comply with the 10-day noticing requirement, because what they're doing is trying to move forward factual issues, understand from one another what concerns might be, and then do things, as I said, just as mundane as specifying dates for status conferences, specifying when briefs might be due. It seems that if these communications could occur organically as people are meeting and working in the office on a daily basis, that what really needs to happen then, if there is a particular concern that the conversation or discussion took place, is that there's a timely subsequent posting of a record of conversation in the record of proceedings that allows people to know that a conversation took place and that the commissioners took some sort of action or reached some sort of decision. This doesn't displace or in any way affect the open and noticed evidentiary hearings that have to take place, where all parties and members of the public participate in an open and public proceeding and are heard. So the solution, perhaps, of allowing the 2 committee members to speak together and have a subsequent posted record of conversation, I think would address an interesting situation that Commissioner Karen Douglas of the Energy Commission raised in prior testimony before the Little Hoover Commission on Bagley-Keene matters. She was recounting her own experience as a member of the 2-person committee, where there were multi-day hearings scheduled out in the desert. Anyone who's traveled to any of those desert locations knows it is several hours from the airport to the hearing location. She was there for many days with an associate member of the committee. They decided, which was sort of unprecedented, that they would actually travel together from the airport to the hearing venue and from the hearing venue back to the airport. At no time, and this is borne out by witnesses, at no time during the car ride to or from the hearings did these 2 commissioners discuss any aspect of the hearings. I mean, kudos to them for complying with Bagley-Keene. On the other hand, what an impractical effect that these 2 commissioners sitting together who are about to hear many days of complex testimony on some first impression issues were not able to speak with one another beforehand to get a sense of what they were listening for or would be listening for in the hearings, what might make a difference to them. nor could they once the hearings were over and all of the evidence and facts and issues were at the forefront of their minds, have any discussion whatsoever about what they had just heard. And I'm not talking about having discussions necessarily to decide the issues or to resolve the factual or evidentiary issues, but just to find out whether or not they are even in some way aligned on what those issues might be. And then to benefit from their respective experience and knowledge to help inform the other on how they might consider or weigh eventually some of that information. Seems to us that this is, again, counterproductive, makes it difficult for the Energy Commission in many respects to discharge some of its core functions. So as I listened to this morning to Mr. O'Neill and Ms. D'Elia and some of the proposed solutions of really not radical changes to the Bagley-Keene Act, but changes that allow these informal, collective, collaborative discussions among commissioners. If we could just have amendments, I think, of that sort, it would do a tremendous benefit, I think, to the Energy Commission and the public as the Energy Commission tries to discharge its duties under the law. Thank you.
Very helpful. Thank you very much. Our third agency commenter is Allison Joe, the Assistant Executive Director at the California Strategic Growth Council.
Right. Thank you very much for the opportunity to speak on this matter. The following remarks provide some background on the enabling statute of the Strategic Growth Council, which is one of the newest entities to be affected by the decision-making and open meetings processes discussed today. The SGC was created in 2008 by SB 732 to coordinate state efforts to support the development of sustainable communities. Mr. Alex, you referred to it as silo busting, and we think about it a little bit as some cat herding and dot connecting as well. The legislation clearly mandates a collaborative process to promote a variety of interagency values and investments, including promoting compact infill development and conversely natural resources conservation, increasing the availability of affordable housing, improving transportation systems, and other efforts designed to support the goals of AB 32 and SB 375. As a practical matter, unifying the efforts of 6 agencies and the governor's office, there are 10 members total, but 7 of which are cabinet secretaries, plus 3 public members. So coordination and working with those member agencies requires clear and constant and effective communication. Recognition of this may be part of the reason that SB 732, as first introduced and amended over the course of the legislative session, contained no mention of the Bagley-Keene Act. But at some point during that legislative process, the council, the statutory legislation was amended to require the council to operate under the rules of Bagley-Keene. This amendment seems inconsistent, though, with many of the other sections and mandates for the SGC, which either openly state or certainly imply the intensity of the interagency communication to be applied in achieving the goals of the legislation. Some examples of our enabling statute in which we are really required to conduct this sort of interagency communication and collaboration include just generally the SGC through our member agencies is charged with identifying activities and programs that those specific member agencies participate in that may be coordinated to achieve the goals, of the council. Staff to the council shall be representative of the membership. For practical and fiscal reasons, that's come to mean that the member agencies contribute staff to the council for the purposes of accomplishing the many mandates of the enabling legislation. This has had the benefit of bringing agencies closer together, as you have seen, and actually working shoulder to shoulder to accomplish many of the objectives of our organization. In addition, the council is to provide data and information to local and regional governments to assist in the development of sustainable communities. And certainly the pooling and coordination of this interagency data and information is very, it is a very practical matter. But the communication-rich process, which requires these decisions at many levels, so the state, federal, regional, local, it requires that decision-making to be reasonably facile and collaborative. Finally, the last example in which we are actively coordinating and collaborating on a number of issues is in relation to the 5-year infrastructure plan. The Council has been directed by mandate to look at consistency of that plan issued by the Department of Finance with the state planning priorities. This mandate directs the state to bring the vantage points and expertise of the agencies with very different missions together to examine critical infrastructure investments and to review the relationships of those investments to the values espoused in the statutory state planning priorities, which essentially reflect need to focus on infill and compact development and equity, looks at conservation of our natural resources, and efficiency of greenfield development if necessary. All of the sections of the SGC's enabling legislation, except for the very section requiring that the Council be subject to Bagley-Keene, require frequent communication and close collaboration between the agencies overseen by the Strategic Growth Council's members. Staff for the Council, with the exception of a very small operational staff, is comprised of delegates from Council member agencies, as referenced before. We refer to the staff as key staff, and they are the pivotal link between the core of the Council and their expertise in their respective agencies. They must be sufficiently well placed in their agency to have a broad, comprehensive view of their agency's programs and operations, and they must have the authority to commit staff resources from those agencies to SGC programs. Persons acting in this capacity are, of necessity, part of their agency's leadership. So what is the challenge in all of this, particularly in reference to Bagley-Keene and open meetings? The requirements of Bagley-Keene draw a narrow circle around the types of communications that can take place between members of a decision-making body or those who could act as a surrogate for the views of a member of that body. Interpretations on the communications that can occur between Council members or their surrogates are generally unclear, specifically with regard to the number of members and the respective views that can be commingled within a venue or topic, the stage in the decision process in which such commingling can take place, the number of discussants allowed for collaborative coordination to occur, and at what level of leadership. All of these items limit the size of that circle noted above. And these requirements currently constrain the breadth and intensity of communication needed in order to efficiently produce the collaborative, coordinated activities and programs envisioned by SB 732. The one avenue currently available for the discussion, coordination, and integration of these multiple member agency viewpoints is to notice and hold a public meeting for any such discussion to occur per Bagley-Keene. Such provision offers no flexibility in the discussion outside a public meeting, requires significant commitment of staff resources to plan for, notice, and hold such meetings, and is generally an inefficient practice. These structures generally act as a deterrent to conversation and actual collaboration amongst the members as well as their staff, and is actually contradictory to the very coordination of the Council's objectives. And I would note that up until probably about 2 years ago, we used to actually have meetings every other month. And the sheer logistics of trying to develop an agenda, get consensus on that agenda without triggering public meetings, and then actually noticing 10 days before, having the meeting, and then literally you're actually developing another agenda for another meeting, made it incredibly awkward and really not the greatest structure to be able to have these kind of decision-making conversations, and incredibly limiting to the operations of the Council. We were essentially running meetings. And so what we have now switched to are quarterly meetings, which essentially help us move things along, but we're still limited by the public meetings that we have. With that, we really appreciate the conversations noted by the other speakers and the panelists. I think that some of the issues are similar. It's kind of nice to have some kindred spirits in the audience. And we look forward to the discussion today to achieve transparency in the public decision-making process while encouraging the collaboration needed to efficiently meet our organizational objectives. Thank you.
Let me add one more observation on the Strategic Growth Council, which is probably fairly unique, because, as you note, that the primary staff, key staff, comes not from the Strategic Growth Council itself, but from constituent agencies, and that they're high-level staff members, and often their views can be attributed to the council members. Under Bagley-Keene, subcommittees can only be 2 members, even though there are 7 agencies reflected on the council. And so subcommittees here may be limited to simply 2 members, precluding any discussion of significant business and in the case of the Strategic Growth Council, building guidelines by staff. So the Strategic Growth Council has this additional layer that sometimes other councils and boards can get around by the fact that they have a bigger staff. Okay, thank you all very much. What I want to do now is to take some public comment, and I would ask folks if they can, agency commenters and the presenters from earlier, if we have you stay, because I think there may be some possibility of having a little bit of dialogue. Before as Stephanie gives me the list of public commenters, I do want to read a little bit of a excerpt of a statement made by Michael Asimov, who was unable to attend today. Some of you may know Professor Asimov. He's a professor emeritus at UCLA and is teaching at Stanford Law School. He's been a frequent commenter on APA issues under California law and submitted a statement, and I'll just read a bit of it. He says, sunshine laws stifle deliberation and do not enhance transparency. The reason to create a multi-member agency is to achieve collegial deliberations and compromise between the different points of view held by the members. Typically, statutes creating multi-member agencies require partisan balance to take advantage of differing points of view. The idea is that collective deliberation contributes to wiser public policy than would be achieved by an agency headed by one person. This purpose is almost completely stifled by sunshine acts. In most cases, the public meetings required by the law are a sham. They're completely scripted. The members of the agency never want to say anything with the public and the media present that they could be used against them. The staff never wants to say anything that could embarrass the members. As a result, the members do not and cannot deliberate, and the public learns nothing about the thought process of the members. He cites some research, and I'll post this on the OPR website. One more excerpt. We should know by now that there are appropriate situations in which confidentiality is protected to enhance deliberation. The attorney-client privilege, the Freedom of Information Act provides that all documents possessed by the government can be disclosed. There's a critical exception, statutorily at the federal level created by case law in California, the deliberative process exception. As another example, consider the state and Supreme Courts which conduct their deliberation in closed meetings. He notes that there are federal workarounds that do not exist under California law. Okay, you get the sense of his testimony, and if you're interested further, I will post that. Let me turn to my colleagues before we start public comment and see if either of you have a comment.
Thank you, and I apologize because I have to leave at 11:30, and so I'm glad to just have a brief opportunity to comment. And I know that we still haven't taken the public comment, but the presenters in the 2 groups were really helpful. And I think what they did, and maybe for the public comment and for me, is they framed the issue very well. And I think on one side is the Strategic Growth Council, which when you have 10 members, 7 of which are cabinet secretaries, and no more of 2 can talk to each other at a given time, and your goal is to break down silos and work together, it is by the very nature of that description dysfunctional. At the other end, and I know it's been hard because it's not been said as clearly, the public has a right to feel like business is being done in front of them and is not being done away. And so the question is how do you take those 2 poles and balance them? And right now it is not balanced really evenly. because it creates very dysfunctional situations in the name of transparency when in fact the transparency isn't happening. And so I really look forward to the public comment for as long as I can stay and for the comments that came from the presenters, because I think they framed that issue. And maybe if some of the public comment can gear toward it, it's, well, where is that middle spot? Where is that place between trying to ensure the public that nothing is being done in a closed room, and at the same time, if two people can't talk to each other in a 2.5-hour car ride across the desert, there's got to be a better way of doing it, and somehow there's something in the middle that gets there. So I just appreciate the fact that that's been framed, and I'm looking forward to hearing people comment on it.
All right, so we have a number of people who want to make comment. Let's start with Tom McBride, followed by Barbara Barkovich. I'm not going to put any time limit on, but if you could, keep it within reason, we'd appreciate it.
Yeah, thank you. I know you have a number of people who want to speak. My name's Tom McBride. By way of background, I'm an attorney in San Francisco. I practiced in front of the commission for about 40 years. I've written a number of pieces of legislation which have been enacted, which affect how commission decisions are handled after they're issued in the appellate courts. But this is about prior to the decision being issued. Just wanted to note at the outset that under Article 12 of the Constitution, the public utilities are not subject to the control of the commission. They're subject to the control of the legislature. And the legislature's delegated that legislative authority to the commission through the enactment of the Public Utilities Act. So it's very clear under both state and federal law that rate setting is a legislative activity. And it would, to me, a legislative body would not want to constrain its sources of information for exercising legislative authority to what occurs in a hearing room. And that is particularly the case with the Public Utilities Commission. If you have been to a PUC hearing in a major utility rate case and you're representing an intervener and you walk in and you sit down, you have your notes and you're all ready to go, and then the door opens in the back and down come a couple of hand trucks with bankers' boxes full of documents, and all the utilities personnel come down, and they can overwhelm the process. So sort of hermetically sealing the commission so that the only source of information the commissioners get with respect to these matters occurs on a formal record in a hearing room is not something that's conducive. It's not going to benefit consumers. It's going to turn that process over to the utilities. I mean, that's probably an overgeneralization, but if you attend a hearing, that's what you see. A lot of experts, a lot of attorneys, and an ability to jam that record full of things that are favorable to the utility because they just have more money. The current that does not mean, however, and I'm obviously advocating for a retention of the current ex parte rules, that does not mean that the decision should not be based on the record. Starting with the original Public Utilities Act, the only standard of evidentiary review of a commission decision was, did it regularly pursue its jurisdiction, which from an evidentiary standpoint meant if there's anything in the record to support the outcome, the commission decision would be upheld. The current ex parte rules were adopted by the legislature about 8 years ago with the enactment of SB 960, Bill Leonard's bill, and which was also coupled with the original Judicial Review Reform Act. And that established the current ex parte rules, and it also established the evidentiary standard of substantial evidence to support a finding. So regardless of what occurs in an ex parte meeting, regardless of what occurs on the record, if there's a finding in the record that supports that decision, it has to be supported by substantial evidence. In recent years, particularly in the last 3 or 4 years, the appellate courts, which have been much more active in taking commission cases, have enforced that. And where there have been decisions where a finding was made that was not supported by substantial evidence on the record, the courts have overturned it. So in my brief time here, I'm basically advocating that a public policymaker listening to this discussion would consider retaining the current ex parte rules. I do agree, however, with some of the comments that have been made that some of the reporting is a little thin. So-and-so met with Commissioner so-and-so and discussed the rate case. The meeting lasted 90 minutes. Doesn't really tell you much. But overall, my view is that limiting ex parte rules, and particularly limiting the sources of information to a legislative body to what happens on a formal record in a hearing room, is not in the public interest. Thank you.
Thank you. Barbara Barkovich, followed by Ralph Cavana.
Thank you. My name is Barbara Barkovich. I'm here representing myself. I'm not being paid by anybody to be here. I was on the PUC staff a million years ago, and I have been practicing for the PUC as an expert witness and a consultant for decades. I have participated in I don't know how many cases and helped write and I don't know how many ex partes communications. I want to say that I absolutely agree with Tom McBride, which is that when I participate in an ex parte communication, we actually talk about what we said. We don't say we talked about something, we say what we said. That should be a minimum standard of disclosure, and I'll go over a couple other recommendations for what also should be requirements at the end of my comments. I disagree with Mr. Strumwasser about banning ex partes for rate-setting proceedings and keeping them for quasi-legislative proceedings because, frankly, sometimes it's really hard to tell the difference. I've participated in lots of rate-setting proceedings which are full of policy content. And if the idea is to allow discussion of policy matters through ex parte communications, then if you can do it in a quasi-legislative proceeding, you ought to be able to do it in a rate-setting proceeding. It may be that the definitions or the process for determining which kind of proceeding one should be reviewed. But it makes no sense to me to say that we can talk about policy in this case openly, and in another case we can talk about it only after filing an ex parte communication according to the rules. I don't mind filing the ex parte. But if somebody tells me I can't even have that policy discussion, that doesn't make sense to me. Most of the work I do, I represent a small non-utility party. And I can tell you that at the Public Utilities Commission, again, I agree with Mr. McBride, there are a lot of proceedings. The Commission has a lot going on. They all intersect, and so it is very difficult to keep an eye on all the ones that intersect in terms of how the decision-making is going to go. And small parties are really seriously disadvantaged. There are times when there's a huge record. The administrative law judges and the staff do their best to condense that record for the decision makers, but nuances get lost. Sometimes there can be an issue that you really think is an important issue, and it just got lost. And so in those cases, really the only opportunity you have is to try to communicate, because once it's in a proposed decision, the only way you can comment is on errors of fact and law. You can't re-argue your policy position. That's considered inappropriate. So for small parties, sometimes that's the best shot you have at actually communicating your concerns. Now, I know we're on a limited time frame here, so I'm just going to make a couple of recommendations about the existing ex parte rules and how they might be modified, enforced, and most of all, honored, both the spirit and the practice. The context that caused the most concern in some of the recent scandals, if I can call them that, involving utility back channel communications with the Public Utilities Commission, they involve violations of the rules. So clearly it's not a matter that the rules were inappropriate necessarily, it's that the rules weren't followed. And that means that the utilities basically knew that the communications would be considered inappropriate if they were filed. So that means that clearly there's a need for enforcement here. Strict enforcement of the rules can prevent future violations on the scale that we've seen in the last couple of years. And again, I'm not attributing that to any existing commissioner or anybody, but the press reports, et cetera, speak for themselves. You could codify a new PUC policy to require a log of all ex parte contacts and check them to see if parties filed the correct ex parte contacts. You can also create a rule that bans ex parte meetings and rate setting cases within 3 days of a PUC voting meeting so no one can circumvent the equal time provision. Given the notification requirements for an ex parte, if somebody gets in there at the last minute, nobody else has the opportunity to respond. This is one that's also near and dear to my heart, which is that the Commission does not, as a practice, serve all parties to a case with all revisions to a proposed decision or alternate proposed decision before voting. Lots of times the actual final changes show up the morning of the vote, which precludes anybody from providing any input on those changes whatsoever. So to avoid such surprise changes, and believe me, they occur, it would be helpful if there were a process to make sure that all those changes were delivered to parties in a timely manner so that they could at least be reviewed and possibly commented upon as appropriate. And because, and again, I think I've mentioned this before, it really is important, and Tom mentioned this as well, it's really important when you do file an ex parte to talk about what you actually talked about and not just say, we talked about something. And the variety of, shall we say that there is substantial variation in how that is adhered to before the Public Utilities Commission at the present time. Thank you for your time.
Thank you very much. Ralph Cavanagh, followed by Michael Day.
I'm Ralph Cavanagh. I am appearing today on behalf of myself, but I certainly don't shrink from my service at the Natural Resources Defense Council since 1979. I was the author of many of those 187 ex parte notices noted by Beverly Grossman Palmer over the period 1992 to the present. I want briefly to focus most of my attention not on my institutional interests, but on my acute sense of the importance of the multi-member agencies that are the focus of this discussion, California PUC and the California Energy Commission. And I have to say I am still reeling from the presentations by Tim Sullivan and Courtney Vaccaro, who were unfailingly constructive and helpful, but who did more than I think I've heard anyone else do, lay bare the dysfunction associated with the well-intentioned 2009 amendments to the Bagley-Keene Act. And in my brief remarks, I want to distinguish between, there are two big themes before us today. What do we do about the Bagley-Keene problem? And what do we do about the ex parte issues? Now, on the Bagley-Keene problem, which unfortunately the legislature has shown relatively little interest in so far. For example, I'm not aware of any pending legislation that addresses this issue, although there's an abundance of interest in the ex parte issues. If humanly possible, we need to conjoin the two. And you have had, I think, presented to you all of the information and material needed to do it. My brief observation on Bagley-Keene, and here I have worked with a number of advocates, longtime advocates before the Commission, with whom I have profound differences on other matters, including Mike Day and Barbara Barkovich. All of us submitted a proposed fix to the problem created by the 2009 amendments, because it's not enough, I think, simply to repeal the 2009 amendments. There is now enough confusion within the agencies, enough difficult precedent in terms of what is a discussion, what is a substantive issue, what is a deliberation, that real clarity is needed, not of abundant word length, but real clarity on the ability of commissioners to do what multi-member commissioners are intended to do, which is actually deliberate, talk informally, as long as they don't formally strike a consensus and take votes. We think there's a way to do that. We've submitted that language to the Little Hoover Commission, and I cannot say enough about Carol D'Elia's leadership in through that body in bringing this issue forward, and I believe when their report is issued this week, the legislature will pay more attention. On the ex parte issues specifically, Commissioners, the one thing I would add to this conversation, and in listening to Michael Strumwasser, he has a very firm lawyer-centric view, understandably, of what it means to be a good commissioner and reach a decision on the record. And he talked about parties to a case losing to their adversaries because of ex parte communications. He talked about the legal quest for evidence-based truth, and he worried that there was too much emphasis in many of these ex parte contacts on what he called non-factual policy arguments. Guilty as charged. Much of what this commission does is all about policy decisions. It should not view its mission narrowly and solely as that of an adjudicator determining the positions of individual adversaries in legal battles against themselves, mediated by attorneys with court reporters. the Commission's role is richer. I agree with Michael Stromwasser on the specific context of the adjudications the Commission does, and it does some, which are all about determining the position and rights of individual parties. But most of what the Commission does, the most important part of the Commission's work, for example, in mediating a clean energy transition for California, is much more about policy, quasi-legislative decisions, where it is critical for parties to be able to engage commissioners just as they engage legislators, with, to be sure, disclosure of the communications, and everything Barbara said about that makes sense to me. My closing, and it's intended as a philosophical overlay on this, is a statement by a redoubtable legal academic 40 years ago. I'm sure he was one of Governor Brown's professors. His name was Grant Gilmore. In his most celebrated lecture, he summed up his view of the role of law in society. I'll just quote the last paragraph. "The better the society, the less law there will be. In heaven, there will be no law, and the lion will lie down with the lamb. The worse the society, the more law there will be. In hell, there will be nothing but law, and due process will be meticulously observed." Let's not go there. Thank you.
I note that you're a lawyer and 2/3 of this group up here are lawyers, so we appreciate your quote. Okay, Michael Day, followed by Martin Mates.
Gentlemen, thank you. Michael Day, I'm an attorney in San Francisco. For 11 years, I held positions in the Commission's legal division, including acting general counsel and deputy general counsel. And since then, I've been representing large and small cities, counties, businesses of all sizes, and trade associations such as solar industry and the wireless industry that have business in front of the Commission. And I have indeed practiced a lot of ex parte communications with commissioners over the years, although I didn't make Mr. Stromwasser's list. What I can say is two things about the ex parte rules and also the Bagley-Keene. Let me address that first. I strongly endorse Mr. Asimow's comments about it. It's very important to note that although the Brown Act provisions that were then put into the 2009 amendment dealt with cities and counties, there are aspects of the way the PUC operates that are very different than local government. There's an extensive process in place for public comment on PUC decisions, not just by the individuals who show up in a hearing and present testimony, but there's disclosure of the decision well in advance of a voting meeting. There is an opportunity for written public comment and reply comments by all parties. And in addition, there are frequently modifications made to the Commission's decisions as a result of this public comment. So there's a tremendous amount of transparency and input in that process already. And for that reason, we think it's not necessary to say that you have to discuss the meeting and in the public meeting and decide the cases there. That's not possible. Even a single utility rate case has so many issues in it that it couldn't be discussed in a single Commission business meeting. It takes weeks and weeks of drafting and analysis by an administrative law judge to come up with a decision. And for the first 98 years of the Commission's history, it was followed by extensive deliberative discussions among the commissioners to decide what were the key issues, what was the key language in the findings and conclusions and decisional paragraphs that needed modification so a consensus could be obtained. There was no problem with this system in the sense that there was no clamor for additional transparency. It essentially was functioning appropriately, and the commissioners could all contribute in the way that I think they're meant to as members of a deliberative body. But however, there were unintended consequences of the 2009 amendment, and for the reasons you've heard from many other parties, including Professor Asimow, we strongly think those should be changed. With regard to the ex parte issue, I think it was mentioned by Tom McBride. I think it's very important to understand that both the U.S. and California Supreme Courts have made it clear that rate setting is a quasi-legislative activity. The fact that the PUC uses trial-type hearings is probably a function of the fact that it was set up in an era when there were contested cases with the railroads, there were contested cases with a limited number of utilities. But when I joined the Commission, you'd see the staff on one side, the utility on the other, and maybe an intervener or two. Now you have PUC proceedings that affect so many stakeholders in the California economy that there are 30, 40, 50, 60 parties in a proceeding. And they've all got policy issues. They've all got issues they want the Commission to deal with. And very few of them are the type that get decided in an adjudicatory fashion. Did PG&E spend $1 million or $4 million to build this substation. That's an adjudicatory issue. That's a factual issue. You can decide that in a hearing. But should we take the costs of that substation and spread it this way over residential, commercial, and industrial customers, or should we change the rate design and shift the cost this way, this time, different than we did last year? That's a policy decision. That isn't going to be decided by facts and cross-examination on the record. And in that respect, the commissioners deserve input from all the policy stakeholders that are before them. And we want to second what was said by Mr. McBride and also by Ralph Cavanagh, that if you were to go ahead with the recommendations to eliminate all ex-parte communications in rate-setting cases, you would do a tremendous disadvantage to every stakeholder before the PUC except one, the very large utilities. And that can't be what was intended by legislation that was to address the concern about the back office communications and so forth. That would be exactly the wrong and opposite result. And in addition to the comments that were made about how many attorneys and paralegals and regulators and expert witnesses the utilities bring into the hearing room, at the expense of the ratepayers, they get their resources paid for by ratepayers. Nobody else does. In addition, the utilities have the single greatest advantage in any PUC hearing because they control all the information. What we're trying to do is figure out what has the utility done? How much did they spend? What did their executives know? When did they say it? That is information they have, and we have to try and tease out of them through discovery. It's extremely difficult and painstaking, and it's very hard, and it means that the utilities have a tremendous advantage in creating a record at the commission. And if ex-parte communications from the smaller parties are banned, it doesn't matter if the utilities can't do it either. It means the record will be based on what they dump into the record, and we won't have the opportunity to tell the commissioners, focus on this piece of evidence we put in. It's buried in this 10-foot pile of information, but focus on this because it's really important. That's the purpose that ex-parte communications serve for the smaller parties that appear before the commission, and we strongly urge that that be retained. Thank you very much.
Thank you. Martin Mates, followed by Sandy McKibben.
Good afternoon. I'm Martin Mattis. I also have practiced as a lawyer for about 40 years before the commission, the first 10 of them as a commission staff attorney and administrative law judge. And since then, for various entities with issues before the commission. For a long time, I worked for small telecom companies trying to cope with Pacific Bell. Most of those clients went out of business, and so I refocused on other areas, and now I mainly represent water utilities and transportation companies. So I have a fairly broad experience. I say I served as an administrative law judge. When I first joined the commission, they were called examiners. One year, the governor didn't want to give them a raise, so he gave them a better title. But in fact, their role functionally is as an examiner. They develop the record for the commission to make a decision. Except in quasi-judicial cases, where now with the reforms of the 1990s, the administrative law judge does issue a presiding officer's decision, which can be appealed to the commission. In all other matters, the ALJ does a proposed decision that will be the commission's decision, or if one of the commissioners wants to have a different one, an alternate. But it's very important to not increase the separation between the staff and the ALJs on the one hand and the commissioners on the other. The gap that has developed that Mr. Sullivan emphasized is a very bad thing. It needs to be rectified, and that needs to be rectified through directing the commissioners to focus on the commission's proceedings. That's where their business is. There are lots of fine conferences for them to attend, but they need to focus on their assigned cases and take responsibility for those cases and supervise them and participate actively in them. There is legislation that requires them to author the scoping memos. There's legislation that would seem to require the granting of oral arguments. That was mentioned that by Mr. O'Neill, that oral arguments at the end of a case would be a beneficial element. The statutes seem to require that, but the commission doesn't often grant them. The commissioners need to be more engaged with the cases, and I think although they have very heavy workloads, and that's a real problem, that they have such broad responsibility, so much to regulate, but they need to be involved. One thing I can say over my 40 years with the commission is I've never seen a corrupt commissioner. I've never seen an instance where a commissioner was on the take. So I don't fear they're talking to each other out of the public eye. They're all public-spirited individuals who take a pretty thankless job, but they have very great responsibility. The law should help them to carry out their functions and not get in the way. We should take them to heaven rather than to hell. And I'd like to also note, ex-parte communications, as has been said, sound bad. Communications are what you're trying to promote. So I really like the reference by Ms. Vaccaro to reports of a timely and subsequent posting of a record of communication. That's a very positive thing, much better than a notice of ex parte communication. So perhaps a little change in the verbiage would help. Thank you.
Thank you very much. Sandy McKibben, followed by Thomas Long.
We were able to resolve it, and we now have one of the best track paths in the nation. But if it hadn't been for the fact that we could go in and talk to commissioners, this wouldn't have happened. So I worry about the fact that there are people out there that don't have the sophistication of most of the parties that you've been talking about today.
Thank you very much. Thomas Long, followed by Jim Ewart.
Good morning. My name is Tom Long. I'm the legal director for the Utility Reform Network, or TURN. We're a statewide consumer advocacy organization. We've been advocating for the interests of residential and small business consumers statewide for 40 years. And I have a different perspective to offer from many of the public speakers who went before me. I want to strongly endorse and applaud the findings and conclusions that we heard this morning from Mr. Stromwasser and Ms. Palmer. I have practiced before the commission, like many of my colleagues who spoke before, for a long time, 30 years for me, and 4 of those years were actually as an advisor to a commissioner, so I worked inside the commission. I have been in many, many ex parte meetings. I've been the recipient of many ex parte meetings, and their findings and conclusions do an outstanding job of capturing the ex parte experience at the California PUC. And I think what needs to be understood is that even when the commission is acting in its most informal type of proceeding, that's the quasi-legislative cases, there still is a public record, a formal record, a record and let's talk about a policy case, a quasi-legislative case. The record would typically consist of an opportunity for all parties, with everyone having a chance to see everyone's comments. Everyone gets a chance to comment. And then there's an opportunity for reply comments. Those reply comments allow an opportunity for parties to correct misinformation, incorrect citations, incorrect facts that are presented by other parties. Then we often have workshops. Again, publicly noticed, everybody can participate, the same opportunity for an exchange of views, and again, an opportunity if somebody makes a misstatement or is going beyond what is commonly understood, there's an opportunity to correct that. So we have and that's the most policy-oriented type of proceeding. Most proceedings, however, at the Commission are what are called rate-setting cases, which are far more formal, in which often there are evidentiary hearings, and in which there's a lot of disputed factual issues. And I take issue with the suggestion that policy is not based on fact. Fact has to be the basis of good policy. And so these factual disputes need to be resolved in a way that's fair and open. So the problem I have with the idea of unlimited ex parte communications that we now have in many instances is that there's no opportunity. I guess another way to put it is ex parte communications are private communications. There is no opportunity if somebody misstates the record, relies on evidence outside the record, just is off the reservation in terms of what are appropriate policy considerations. There's no opportunity for me as somebody who is aggrieved by those statements to correct them, to respond to them, or otherwise deal with them. And it makes a mockery of the remainder of that formal record that we had, that we developed through comments and workshops and everything else. It just, the two don't fit together. And I wanted to highlight one of the findings of Mr. O'Neill, which I thought was very important, which is that the staff feels undervalued because the commissioners seem more interested in hearing from the utilities and the parties rather than the staff. And that resonates entirely with my experience. If the commissioners and their advisors are spending all of their time speaking to outside parties and not relying on the expertise of the staff is just not going to be motivated. And you're not going to get good people at the commission. They just don't feel engaged in the process. So I think Mr. O'Neill made a lot of important points. Where I disagree with Mr. O'Neill is that quasi-legislative cases, which again are the most policy-oriented, should be done without any disclosure of the ex parte, of the private communications or the ex parte communications, for the reasons I've just given. There needs to be an opportunity for all of us to understand what everyone else is saying and to make that record meaningful. Otherwise, the concern of the public is going to be that the commission is ultimately basing its decisions on information that is private, and the word is often used, secret. Secret, that's the word that editorial boards in the state of California are now using, and that's not the way we want things done at the California PUC. So thank you very much.
Thank you. Jim, looks like Ewert.
Thank you very much. My name is Jim Ewert. I'm General Counsel for the California Newspaper Publishers Association. And I am the attorney that apparently single-handedly allowed the state agencies to develop a collective concurrence after my comments. A couple of things to keep in mind here. The open meeting laws, specifically the Bagley-Keene Act and the Brown Act, apply to many agencies and many government entities, not just the PUC and not just the CEC, which may or may not have some unique circumstances. But one need look no further than the California Coliseum Commission negotiating away the rights to the Coliseum in secret, or what happened in the city of Bell, or the recent allegations that have caused the PUC to, or the public with respect to the PUC, to have mistrust, suspicions, and doubts. And so it's important that these laws be as strong as they possibly can. And when they were first created, it was to prevent that sort of misconduct. It's not the good actors that those laws really affect. It's the bad actors. And when the people in 2004 passed an initiative to create a constitutional right of access to meetings and to records, 83% of those voters thought it was important enough to put into the state constitution. in 2014, when it was amended, when the state legislature decided to suspend key provisions of the Brown Act and the Public Records Act. The people of the state of California said that is not good enough. We're going to remove those two areas of the law from the state mandates that led the legislature to try to save money. But all that said, in both cases where you have the Bagley-Keene Act or the Brown Act, the legislature created a presumption that people had to access the decision makers of state and local agencies. And the presumption says that no body shall meet unless in the open to hear, discuss, deliberate, or act on any matter that falls within their subject matter jurisdiction. So if you're taking a look at the amendment that was made in 2009 that California newspaper publishers and the League of California Cities negotiated, at least at the Brown Act level, which was then put into place at the state level under Bagley-Keene, it simply mirrored that prohibition so that those individual conversations, those informal discussions, had to take place openly and publicly. Now, the legislature has created a model to balance situations where there is a greater public interest, where those conversations should take place, or where the public is better served, where those conversations should take place outside of public view. And they created several different closed session exemptions to recognize that. They are narrow in scope, and they're limited in how they can be utilized by the specific agencies that use them. That is the model to be used here in balancing the issues. And it may be that a new closed session exemption needs to be created if the case can be made that is narrow and workable. But if we're looking at simply repealing the serial meeting provision that was added to the law in 2009, that is unworkable. And let me explain why. If those informal conversations can take place, there's nobody that is going to be there to say, hey, the scope of that conversation is trending over into an area where you're not supposed to talk about it. Or a quorum is established by these informal discussions. Or by a wink and a nod, consensus is reached. So by simply saying, oh, well, as long as there's no consensus that's reached, it's okay, it's so easy to fall over into that next category where that simple discussion becomes consensus. And so we would urge you to tread very lightly in this area and consider the model that the legislature has already set before you with respect to changing the law here. Thank you very much.
Thank you very much. Well, that was a broader comment than some of the earlier. It became a little more PUC-centric than perhaps we had intended. But having said that, I wonder, Ed O'Neill, if you could identify, you wanted to go to two categories rather than three for ex parte. And I think one of the issues kind of raised by that is where rate setting fits in your view between the two possible categories.
Right. In thinking about the recommendation that I made this morning, I did go back and take a look at different proceedings categorized under the current rules as rate setting. And a number of the public speakers commented that rate setting under the law based on judicial precedent is considered quasi-legislative in nature, and that is correct. Going back and looking at what actually occurs in rate-setting proceedings before the Commission, however, I discovered that not only are there lots of issues that pertain to the rights and obligations of individual utility customers or utilities or customers, but also broad policy type issues like Mr. Day pointed out. So if you were to look at the proceedings currently categorized as rate setting and try to decide where they would fall under the two-scheme proposal that I suggested, some of them would fall into the quasi-judicial adjudication side of the House. Others would fall in the quasi-legislative policy side. But I don't think that's particularly complicated. And I think if that division was properly made, it would be totally appropriate in terms of protecting the rights of individual parties in proceedings that affect the individual rights and obligations of utilities and customers, and also permitting the agency to discuss more broadly policy and political issues that affect broader classes of utilities and groups of customers. So the proceedings would actually fall part in one category and part in the other. And that would be something to work out in legislation.
Thank you. So let me ask the other presenters and commenters from state agencies if you have any further comments at this point before I turn to my colleague, Secretary Rodriguez. You don't have to, but just, okay, great. So thank you for that. Matt, do you have a comment at this point?
First, I wanted to thank all the presenters and the public speakers for thoughtfully discussing the issues. I will freely admit that when it was suggested that I should be hosting some sort of workshop here on Bagley-Keene and ex parte communications, that I won't say I ran screaming from the room, but it was not something that I was necessarily looking forward to. Particularly given my many, many years of advising state agencies on how to comply with ex parte and Bagley-Keene and Brown Act requirements. It's a very, very complex and difficult area of the law. And it's difficult because, and you've heard some of the issues teed up here, on one hand, there is this public expectation, and I think it's a very legitimate one, that they know the reasoning that goes into the decision that is being made, the decisions that are being made by public bodies and commissions and councils and boards. And they need to hear why agencies or boards are taking the actions that they are and what's gone into that decision. On the other hand, the issues that we're asked to deal with at government are incredibly, incredibly complex. And they benefit from a thorough discussion and examination and exchange of perspectives and ideas. And it's frankly not always feasible to have those discussions in a public hearing context because you want to encourage candor, you want to encourage an exchange. It can take quite a while sometimes to root through these issues and look at an issue from a scientific basis, from a legal basis, from a practical basis, from a business basis. And so is it practical to have all those discussions in a public setting? That's, I think you've heard today, difficult to do in certain situations. Additionally, as you've heard a little bit here, and it's actually something that could be discussed more, there are a wide variety of decisions that are made by government entities. You've got the SGC on one hand that is really basically making grant-making decisions or just policy decisions. Then you've got the quasi-adjudicative decisions that are being made on the other side. And you have to ask, is there really a one-size-fits-all set of requirements that can fit to this wide variety of decision-making that is made by this wide variety of boards and councils? I think the testimony here has been very helpful. It has raised some interesting issues for me. I'll certainly go back and discuss it with representatives from the administration. And we'll think about what's the best approach to take here. Because they're difficult issues, and they really are questions of how do you make good decisions, but how do you make good decisions and explain those decisions in a way that will gain the trust and a sense from the public that they understand the basis for these decisions, and they're not really being made in some smoke-filled room or through some special consideration that's being given to some group because they've developed some personal friendship with the decision makers. So that's the balance that we're trying to find as we look at these rules and requirements. Let me say that I do see a distinction, and this comes from being an attorney, between ex parte communications having to do with quasi-adjudicative matters and matters that are quasi-legislative. It's very clear. Yeah, there will be many attorneys in hell, I'm sure, perhaps myself included. But you know, there are rules that you want to have attendant to quasi-adjudicative decision making, and you do really want to make sure that those decisions that decide personal rights are based on the evidence and the arguments that are known by everybody. And so that's why you have to have special rules, I think, ex parte rules attendant to quasi-adjudicative decisions. Quasi-legislative, as we see with the legislature, you want to hear a variety of perspectives when you're going into legislation. Then the question is, does everybody have fair access to the decision makers? That's a slightly different question than the ex parte decision that you make in a quasi-adjudicative decision. And how do you make sure, however, that one side isn't getting a disproportionate amount of time from the legislators or the decision makers? So we've heard some ideas on how we might resolve that. So I see the distinction there, and the rate making, where that fits in here, is an interesting question. I'm just thankful that the PUC is not in Cal EPA. And I'm sure we'll come up with some suggestions on how to deal with those issues. But I just want to end by saying this has actually been a very, very helpful workshop. I've appreciated all the testimony, and I appreciated the tone and tenor of all the comments that we heard here today.
Thank you for that. And just briefly from me, other than to echo Secretary Rodriguez, thanking everybody for comments, for the tenor, and for the participation. I've learned quite a bit. First of all, I think it's quite clear that some of the Bagley-Keene issues are separate from some of the ex parte issues. Both of those don't apply to all agencies, so it's something that I think, while we need to think about them together for some of the reasons that were discussed today, I think we should also think about them to some extent separately. And what I think we're going to do as an administration within our deliberative process is to figure out where we might go from here, what possibilities there are in making some changes, whether those changes should be, as my civil procedure professor used to say, either with a scalpel or with a sledgehammer. And we've heard some different perspectives on that, so I think we have a fair amount to think about. And I'm sure this conversation will continue over the next couple of months. I do want to observe that my experience over the last 4.5 years, particularly with the Strategic Growth Council, has been that the Bagley-Keene requirements have made meaningful process and decision-making very difficult for that particular entity, and I'm hoping that we can find a good pathway that works for a number of entities that are in a similar position. So with that, ahead of schedule, thank you very much for being here. If you run into a PUC commissioner, please do not do a drive-by ex parte, but thank